Well, the very key thing is an exit strategy. In Chapter 11, the goal is to propound a Chapter 11 plan of reorganization that the creditors are willing to accept. And that means we have to have an exit strategy, something that shows both the creditors and the court, and for that matter, the Office of the U.S. Trustee, that we've got a plan that makes sense. There is going to be future income that's sufficient to take care of the plan, or perhaps there are assets to be liquidated that can meet the requirements of a Chapter 11 plan. So the key thing is exit strategy. Now, within that, one of the key things in dealing with another person in a negotiation is you have to convince the person on the other side of the table that it's in that person's interest to do what you're proposing. If you're going to appeal to compassion, oh, can't you help me out? You've already lost. So somewhere along the line in that plan, you're going to have to put forward something that convinces the creditors that their best option is to go for your plan. How that's done varies from creditor to creditor. Some creditors are out for blood, others are more realistic, and it's just the money. One of the requirements of a Chapter 11 plan is the debtor has to repay its creditors at least as much as they would have gotten if the debtor had gone through a Chapter 7 liquidation. Now, when a business files a Chapter 7, it's going out of business. All of its assets are seized by the Chapter 7 trustee appointed to the case. They're liquidated, and then the proceeds are used to pay creditors. In a Chapter 11, the goal then is at least to pay back the creditors what they would have gotten in that Chapter 7. So one of the many things we do is an analysis of the values of all of the assets, discounted, of course, by the cost of sale and any debts encumbering those assets, to come up with the dollar value that the creditors would get in a Chapter 7. So that's the minimum that we can get away with paying the creditors over the life of a Chapter 11 plan. But that might not be enough to encourage a creditor to vote in favor of the Chapter 11 plan. So sometimes, if it's possible, we put in a little bit of a sweetener. Well, you would have gotten this dollar amount in a Chapter 7 liquidation, but we're going to pay you a bit more in the Chapter 11. So that can make the Chapter 11 plan look a little bit more attractive to creditors. Because unless you're doing what's called a Subchapter 5 Chapter 11, which is sort of a streamlined one, you're going to have to get the creditors to vote in favor of the plan. And while you can get the plan confirmed if not all the creditors vote in favor of the plan, if you have what are called non-consenting classes that refuse to vote in favor of the plan, as long as you have a consenting class, you still can get the plan confirmed, but it triggers a rather draconian result called the absolute priority rule that says that the business is going to lose all of its assets. They have to be part of the liquidation, and the only way to get them back is to buy them back from the bankruptcy estate. So that leads to something that I think helps to have in mind as a picture. Before filing the Chapter 11, the debtor has assets. The debtor has debts. The filing of the bankruptcy petition creates a bankruptcy estate. What goes into the estate is all of those assets, and those debts become claims against the estate. And that's really why that Chapter 7 liquidation requirement is there, because if the estate were liquidated and the creditors would be paid, they would get that minimum amount that would be available in Chapter 7, which is why we want to give them more. Now you might say, well, wait a minute, if that's all that's available, how can you possibly put in a sweetener? Well, the sweetener is based on future income. So one of the things that we have to disclose in a document that we file along with the Chapter 11 plan something called the disclosure statement. We have to disclose what's available to pay creditors. Now, there is a lot more that goes into the disclosure statement. In essence, it's a financial CAT scan with a history. How'd you get to where you are? Where are you headed? And so in that financial disclosure, what we want to put is some sort of a picture of future income. What's going to happen as the debtor marches into the future? Is there going to be enough future income to satisfy that Chapter 7 liquidation requirement and, in addition, pay that sweetener? Having said that, there are some creditors that still have to be paid 100%, even if other creditors don't get paid 100%. Some examples, well, secured creditors get paid 100%, and they may be getting interest on top of that. And then certain priority creditors have to be paid 100%. Those are creditors that are unsecured creditors that Congress, in its extremely finite wisdom, has determined should be given better treatment in bankruptcy than general unsecured creditors. A classic example, most tax debt. Tax debt, with some exceptions, is given priority status. That means that the tax debt has to be paid in full. Now, there's an interesting little wrinkle on the tax debt. While you might have a plan that lasts typically for 60 months, 5 years, you might not get that plan confirmed for maybe a year. So you have been in the Chapter 11 for a year, you finally get the plan confirmed, you might say, well, I can pay that tax debt over the next 60 months, but that's not what the law says. The law says, as far as tax debt goes, measured from the day we file the petition, the tax debt, the priority tax debt, has to be paid back 100% within 60 months. Not 60 months of when the plan is confirmed, 60 months of when the petition was filed. So that's another factor that one does have to keep in mind in crafting a plan, that not only do you have to have enough in the way of future income to take care of the general unsecured creditors, but those special debts, such as tax debts, they're going to have to be paid 100% within 60 months of the day you file the bankruptcy petition. As a result, what we generally encourage debtors to do is to set up a separate account where they're going to be depositing money each month to pay tax debts. This is before the plan is confirmed. Right from the get-go, if there are tax debts that are priority tax debts, the debtor will open up a special tax account and deposit money as the debtor gets income into that account to take care of the fact that we've got maybe as much as a year, sometimes even longer, where you're not paying on those tax debts, which shrinks the amount of time you have available once the plan is confirmed to pay the tax debt. Now, one of the things that the debtor is required to do as soon as we file the bankruptcy petition, we usually have the debtor do it maybe a little bit before, is close all the bank accounts and open up new accounts called debtor in possession accounts. The debtor in a Chapter 11 bankruptcy serves as sort of a quasi-trustee, and that term that we use is debtor in possession. So that debtor then will open up these various, well, they're affectionately known as DIP accounts, DIP for debtor in possession. And so one of the DIP accounts we have the debtor open up is for payment of tax debts. There are other things that come up, but if I can summarize, exit strategy is crucial. So when I talk to somebody over the phone who's called to say, yes, I want to put my business into a Chapter 11, I'm going to start poking around to see, do we have an exit strategy? What that means is if somehow you could end the debts, would the business be successful? And if the answer is yes, the business will be successful, then we have to look at what is available on top of the success available to pay creditors. So the long and short of it is we're looking for a good exit strategy, and that may be a bit complicated.